Welcome to a fresh episode of Legal Wrangle, where we will track major judicial developments in the realm of domestic taxation. For this, we have selected three important cases. First, where belated application for refund claim was denied without examining veracity of reasons explained by taxpayer for such delays. Second, where sufficiency of cause explained by the taxpayer was judged by the third member bench for deciding condonation of delay in filing the appeal. And third, where penal provision of section 43B was invoked for failure to pay nomination charges to the state government. The SSE in this case had approached the High Court challenging the denial of refund by revenue authorities on the sole ground that the application filed by him claiming refund of excess tax paid was filed time barred. The SSE also challenged the action of IT authorities in refusing to condone the delay without examining the reasons explained by him.
Let's see what the final outcome of the High Court was. It is not permissible for the Revenue Department to directly reject the application filed under Section 119 Clause 2 Subclause B for condonation of delay without conducting any inquiry with regard to the reason for such delay. Once reason for belated application stands adduced, then IT authorities should try to consider the same and deal with the case on merits instead of disposing of the matter on technical grounds. If the taxpayer has to be refunded as per the claim made based on the documents, then IT authorities should refund the amount and it cannot be rejected on technicalities. It is fit case for remand if refusal of condoning the delay is solely based on the technicalities, not on merits.
Now let's move on to our second case, where the matter relating to condonation of delay in filing of appeal stood escalated to third member due to differences of opinion of accountant and judicial member. With regard to the petition filed by SSE praying for condonation of delay, the accountant member took the view that the SSE had failed to show that it was prevented by sufficient cause in filing the appeal belatedly. Accordingly, the delay could not be condoned and the appeal of SSE was not liable to be admitted. The judicial member, however, took the view that the explanation given by the SSEs along with the relevant documents clearly demonstrated the bona fide and sufficient cause for non-filing of appeal within the time limit. Accordingly, as per him, the delay should be condoned.
Let's see what the final outcome by the third member was. If there is lapse on the part of legal counsel, then taxpayer should not be found fault with unless it is shown that blame was put on counsel with malified intentions in order to cover up the mistakes of the taxpayer. Mistake on the part of legal counsel constitutes sufficient cause in matters relating to condonation of delay. Delays in preferring appeals are required to be condoned in the interest of justice if no gross negligence or deliberate inaction or lack of bona fides is imputable to the party seeking condonation of delay.
Now let's move to our last case where the taxpayer, that is a civil constructor, was burdened with additions upon his failure to comply with the provisions of section 43B. Substantiating his case, the SSE pointed out that although the service tax collected from customers on behalf of the government was deposited after due date of filing returns under section 139(1), however, the applicable interest for such delay was also paid. Not satisfied, the AO concluded that the provision of section 43B mandated payment of tax within the due date of filing income tax return.
Now let's see what the tribunal has finally decided. Provisions of section 145 clause A does not require inclusions of service tax amounts in the purchases or sales or impose an obligation to reflect such amount as part of the taxable turnover. If no deduction is claimed by the civil constructor in its profit and loss accounts at the time of actual payment, then interest expenses cannot be added to its total income under the provision of section 43B.
With this, we wrap up this episode of Legal Wrangle. Keep watching TIOL Tube for our upcoming episodes. Thank you for watching and goodbye.